Hi, I'm Mark Schroeder, the head of client relations at GSHC Surrogacy Agency, and today we're speaking to Casey O'Connell, an attorney at the law offices of Falletta and Klein. Casey, how are you doing today?
I'm great, thanks for having me.
First question, Casey, what is a pre-birth order and when is it established?
Great question. So under California law, when two parties enter into a surrogacy contract, that's kind of the first phase of the arrangement. The next phase, once the surrogate becomes pregnant, is to go to court and ask the court to declare the intended parents the legal parents of the child or children the surrogate is carrying. So the end result of that court process is what we call a pre-birth order or a pre-birth judgment. And more specifically, what that judgment states is that the intended parent or parents are the legal parents of the child now, that the surrogate and the surrogate's partner or spouse are not the parents of the child, and that some other details about who's responsible for the child's healthcare expenses and how to prepare the child's birth certificate as well. So all that's included in the judgment or pre-birth order. And then as far as when that's established, our goal as a firm, and we strive with our clients to begin that process around the 15th to 18th week of gestation. Typically, we have the judgment entered by the court before birth, just depending on the pregnancy, of course, but that's usually entered around the 25th to 28th week of gestation. So that judgment's in hand when the surrogate goes to the hospital to deliver.
And how long does that PBO process take on average?
So depending on when we start, because we're not always provided information when we would want it, so we don't hear about a pregnancy sometimes until a little bit later, but when we have the information, we request answers to questionnaires from our clients, from the IVF physician and from the surrogate's attorney and the surrogate. So when we get that information, then we draft the judgment documents. We send those out to the parties. Once they're returned to us signed, we file them with the court, and then we wait for the court to process and enter the judgment. There's no hearing that needs to be attended. There's no proactive steps that need to be done once that's filed with the court. We just have to wait. And typically the entire duration of that information gathering, preparation of documents, and filing and waiting is 2 to 3 months. So it's not an overnight process, and it can go quicker if parties return the documents to us quicker. And but that's on average about the time it takes. And right now it's a little bit delayed as well because courts are operating with minimal staff because of the virus. So some of the judgments are being delayed. So it's a time-sensitive process, but it does take a bit of time.
Can a PBO be established after the delivery of the child?
Yes, under California law, both before and after we can obtain that judgment. So as you can imagine, pregnancies can be quite unpredictable. Most of them are straightforward and go full term, and we have the judgment in hand before the baby's born. But we do have those cases where children are born prematurely, and that judgment might be pending with the court at the time. So we can go to court and obtain that either before or after the birth of the child.
And for international intended parents, how can they establish parental rights in their home country?
So that's a difficult question to answer in one response because every home country is different. What happens here in America is they're declared under the laws of the United States to be the legal parents of the child. Now, depending on where they're returning to, they then have to register their child, so to speak, in their home country, their country of residence or citizenship. So each country is different, but from our understanding and the needs that go along with the judgment they'll obtain from a court in California or wherever their surrogate may give birth, they take that back and then complete some paperwork with their home country. We recommend that they speak to an attorney in their home country well in advance of this to plan for what will be needed. But it's as simple as returning home and then just meeting with the authorities that govern that process in your home country. But obviously there are certain countries that are a little bit more difficult, and some planning needs to be done depending on certain factors such as the status of the relationship, whether you're married or not, the composition of the relationship, whether it's same-sex or heterosexual, and then also the genetic makeup of the child. So all those factors come into play depending on what your home country is.
Can same-sex international couples both be listed on the birth certificate of their child?
Again, very dependent on the home country. So for example, in Italy, the original birth certificate for a same-sex male couple cannot have two fathers on that birth certificate under the current laws and from what I understand. So we usually obtain a birth certificate with just one father and then ask for the authority to amend that birth certificate later to reflect both fathers. So again, it's very dependent on the home country.
For international intended parents, what happens if they're not in the United States for the birth of their child?
Yeah, that's a good question. So what we've done and some documents that we offer our clients to protect them in this regard is if the parents cannot be present for the birth, whether that's because the birth was premature or because of the pandemic that we're currently experiencing and the travel restrictions imposed as a result, then we can have the parents sign what's called a limited power of attorney or a nomination of guardian for their child to nominate a caretaker to take custody of the child upon discharge from the hospital, care for the child just as if they were the parent until the parent can arrive. So that's how we protect them against not being present when the child's born.
And how do international intended parents return to their home country with their child after the delivery?
So there's some paperwork here, obviously, that needs to be completed first. So when the child is born in the United States, they're automatically a United States citizen under the laws of this country. So when a child is born here, if they're a citizen, to travel outside of the country, the parents will have to obtain a U.S. passport for their baby. So there's that process to go through. Also, there's the process of obtaining their birth certificate from the county in which the child is born. So that process can take weeks of time, depending on what's going on in the world. Right now, it's taking a little longer because of the virus. Traditionally, it can take 2 to 4 weeks, sometimes 6 weeks to be present in the U.S. with their child before they can take the child out of the country. In addition to that, depending on where the parents are returning to, they would have to visit a consulate or embassy of that home country here in the U.S. to address any sort of documentation that that home country would need as well. So for example, there are documents that if the parents are coming from China and returning to China, they have to go to a Chinese embassy here in the U.S. to complete some documentation there before they can do that as well. That process does not take as long as the passport and birth certificate process, but it's an additional step.
And how long do international intended parents have to wait before they can return to their home country with their baby?
Yeah, so I'll give you 2 answers here. So let's think about maybe we're in a world where the virus isn't affecting everything. So in a normal functioning society, they have a few options here. The birth certificate process depends on the county where the child's born. For example, in San Diego County, where we office, we can have the birth certificate prepared more quickly than some other counties around California, just because they function a little differently. So we usually advise our clients to expect the birth certificate process to take 10 to 20 business days, depending on the county. Once they have that birth certificate, they can then go get a passport. They have the option to expedite that when the government is functioning as they normally would, and they can have that passport done in a matter of a few business days if they pay to expedite that. There's also a little rule that they have to have their travel back home planned within the next 14 days if they can, to even be able to expedite that passport. So there's some timing to plan there for that process. If they don't expedite the passport, that can take 4 to 6 weeks to have that done and sent to them. So it's just a matter of their personal preference, how long they can stay here, and then also whether they're able to expedite anything or want to. Now, if we're in a virus world like we are right now, the expedited passport services, from what I understand, are not offered right now because government employees are not at the office. They're not able to facilitate that service. So passports are taking upwards of 6 to 8 weeks right now because of the virus outbreak.
For international intended parents, will their baby be a United States citizen?
Yes, that's a simple rule here in the U.S. If the child is born within the geographical area of the United States, they are a U.S. citizen.
Will an international intended parent's baby have dual citizenship?
And that's another question that depends on the country they're returning to. So some countries will allow the child to be a dual citizen. Most of those countries are in Europe, from what I understand. If the intended parents are from China and returning to China, the child cannot be a dual citizen of the U.S. and China. So again, another question that depends on where they're coming from and where they're returning to.
For international intended parents, how often do they have to travel to the United States during the surrogacy process?
I guess from start to finish, that depends on where they are with their biological assets. So have they created an embryo yet? Is that here in the U.S.? do they need to come over here to do that process? So that could be one trip to have that done. Outside of that, their presence in the U.S. really isn't needed until we recommend about a month before the due date. They come over here and be ready for the child to be born and to care for it and take custody and manage all the paperwork we just discussed. So that's one or two, if maybe only one, if they already have the embryo created and it's here in the States.
What happens if a surrogate baby is born prematurely?
Yeah, so it depends on where we are with the judgment that we discussed. So if a child is born before that judgment is entered, in addition to that limited power of attorney that I mentioned earlier, where the parents can nominate a caretaker for the child, we have some other documents that we implement for our clients to protect their parental rights and to protect the decision-making authority over the child. Because let's say, just for an example, the surrogate gives birth before we have the judgment from the court. The hospital will consider her to be the legal parent of that child because there's no judgment telling them otherwise. Now, most hospitals are familiar with surrogacy and they're not going to cause a lot of problems at the outset. But what we want to make sure is when a child's born prematurely, first and foremost, the health of the child is paramount. So we need someone there that the parents have comfort with to make decisions for the treatment of that child. So we have the surrogate sign a power of attorney nominating the parents to be the decision maker for the child because there's no legal judgment to say otherwise yet. And then the parents, whether they're here, they can make the decisions then under that power of attorney. If they're not here, then they can nominate an additional caretaker in that limited power of attorney that I mentioned before. So it's a chain of authority there granted through powers of attorney. And then we also go to court and request the entry of the judgment on an emergency basis because the child's born and decisions need to be made. And as the parties have expressed in their contracts, the intended parents are the parents of the child. We just need the court to recognize the urgency of that situation when the child's born prematurely.
How long can their surrogate baby stay in the hospital after delivery?
That's a great question. So if the parents aren't here and they have trouble getting here, which is a hassle right now given the travel restrictions, the hospital will care for the baby as long as the baby needs care. So until that baby is medically cleared to be discharged from the hospital, the baby will stay in the hospital. Now, when that baby is cleared to leave, that becomes a problematic situation because the hospital will then charge the parents significant sums of money to care for that child if it's been cleared to discharge and no one's there to take custody of the baby. So that's why we implement those powers of attorney to make sure a caretaker is present if the parents cannot be, to take custody of the child and avoid those expensive charges from the hospital. So I guess there's no set duration really. If the baby's in the NICU and needs to be in the NICU for months because of a very premature birth, then it could be months. Typically, if the baby's born healthy, it's 2 to 4 days before they're cleared for discharge. So that's why we also try and plan ahead before due dates, or if we hear any indication of early labor, to get a caretaker there and be present for that potential circumstance so we can avoid those costs. And also to make sure that the child is properly cared for.
So as an intended parent, how do I pay for the surrogate's medical expenses and then also the baby's medical expenses during the journey?
I'll start with the surrogate. So as part of the surrogacy contract and under California law, there has to be some provisions in the contract addressing how the parents will pay for the surrogate's healthcare. So they have some choices. They can pay directly out of pocket all the costs themselves. Most of the time people don't do that. They obtain an insurance policy for the surrogate and pay the premiums of the policy for the surrogate. They also pay any co-pays that are owed under that policy, any deductibles, and any uncovered medical expenses as well if those arise. So the parents are contractually obligated to pay those things for the surrogate. If there's complications that arise, the parents also pay those premiums for a set period of time after birth or termination of pregnancy to make sure that the surrogate's covered for a period of time there as well. With the children, the similar options for the parents. They can choose to pay directly out of pocket cash themselves to the hospital, or they can look into and obtain an insurance policy for the child. And that goes into effect once the child's born and would cover them for their costs while they're treated at the hospital. Again, the parents would owe co-pays, deductibles, and things owed under that policy. Alternatively, they can use the funds in their escrow account if there's enough funds there to pay. That's just a case-by-case determination on the source of the funds, really, but those are the options as to cash pay or an insurance policy.
I'm Mark Schroeder, and this has been a conversation with Casey O'Connell from the law offices of Falletta and Klein. Casey, thank you so much for your time today.
Thanks, Mark. Anytime. And if your clients ever have any questions, feel free to reach out. We're happy to help.